Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Hello and welcome to SCOTUScast. I'm your host, Justin Drower, on behalf of the Faculty Division of the Federalist Society. We're here today to discuss Groff v. DeJoy, which was argued before the court on April 18th. It's my honor to introduce our guest today, Hiram Sasser. Mr. Sasser is the Executive General Counsel for the First Liberty Institute, where he oversees First Liberty's litigation and media efforts. Mr. Sasser's practice focuses primarily on First Amendment and other constitutional and civil rights issues. He has numerous appearances on ABC, NBC, CBS, Fox News, CNN, and the BBC, as well as being heard on various radio stations throughout the United States, Asia, Africa, and Europe. In 2016, Mr. Sasser took a leave of absence to serve a temporary assignment as the Chief of Staff for the Attorney General of Texas. He currently serves as an adjunct professor of law at both the University of Texas at Austin School of Law and Oklahoma City University School of Law. He is also a co-counsel in this case representing Mr. Groff. And with that introduction, I'll hand things over to Mr. Sasser.
Oh, thank you. Thank you so much. Well, this was a fantastic case, starting from the very beginning. We came in at First Liberty to represent Gerald Groff once it got to the Third Circuit, and brought in Baker Botts with Aaron Street as our lead counsel with us at the Third Circuit, and then on to the Supreme Court. Just give you a little factual background just to kind of get a flavor for this. Lancaster, Pennsylvania, it may seem familiar to a lot of folks. It's the area of, it's really called Amish country. And a lot of people visit that area because, it's kind of fun to see, way people lived, some time ago and continue to live that way by religious choice. And it's kind of, I call it the land of religious exemptions in a sense, because it's where, and religious accommodations, because it's where everybody is accommodating, like on the roadways, just on an everyday basis, you're accommodating somebody based on their faith. And so it's just fascinating to me that the case came from there. But Gerald, I think, is a 12th generation person living in Lancaster, Pennsylvania. And I apologize, I'll sometimes call it Lancaster because I'm from Texas, but I know they call it Lancaster there, so I slip it a little bit. But Gerald Groff grew up there in Lancaster and went off and served as a missionary for a number of years in various capacities in Asia and Africa. He decided he wanted to come back to Lancaster and to start a career. And the post office was a great place for him in his mind because, well, he has a religious objection to working on Sundays. He had grown up as a Mennonite, but now considers himself an evangelical Christian, but is very committed to honoring the Sabbath. And the post office, they didn't have any Sunday deliveries and no one worked on Sundays, and it was great. So Gerald got a job as a rural carrier associate. That position is literally a position that he can end up doing any number of routes or any number of things in the area, and enjoyed that for quite some time in the Quarryville post office until Amazon cut a deal with the Postal Service. And so that's what led to Sunday deliveries for the post office. And in the beginning, the post office accommodated Gerald, and eventually decided they were not going to accommodate Gerald. And what's fascinating is they were accommodating Gerald when they took away that accommodation where he did not have to participate in the Sunday deliveries. he was very close seniority-wise to becoming a full carrier with his own route, and he would have been exempt from Sunday deliveries. So he probably only had a few Sundays left that he would have to violate his faith. But his faith was so strong, he said, I can't do that. So he chose to transfer to Holtwood, which is another postal area, another post office that is more rural, and no Amazon deliveries were happening at that time. He forfeited all of his seniority and went back to the back of the line. And but of course, Amazon deliveries came there as well. The one of the fascinating things about this case is that the government, and I'll highlight this a little bit later, but the government made a lot of hay over the fact that, well, this is a small post office. There's only a few postal workers. Well, goodness sakes, if he can't deliver on Sundays, that puts this burden on just a handful of other people. But for the most part, what they did in that area was that all the rural carrier associates would report to the Lancaster Annex, and they all became a fungible resource. So you might have 40 of them showing up on a particular Sunday to go deliver around maybe approximately 20 or 22 routes. And so sometimes only 15 routes. And so as a result, there were plenty of other folks, not only who could do it, but many of them were enthusiastic about doing so, because just as Gerald would have to be paid overtime because he'd already worked too many hours that week to deliver on Sunday, so too would the other anybody who filled in for him anyway. So the case arose because eventually Gerald resigned after a series of disciplinary actions, and instead of facing the discharge right at the last moment, Gerald resigned and sued and lost at the district court, lost 2-1 at the Third Circuit, and then here we are at the Supreme Court. Well, the argument is really fascinating because essentially what you have is on the law under Title VII, which is how this case was brought against the U.S. Postal Service. Under Title VII, Congress passed the Civil Rights Act of 1964, which was later amended in the 70s to incorporate some additional changes that'll come into play in a second. But what's fascinating about it is that they had the undue hardship language. And so in other words, you as an employer, you have an obligation to accommodate the religious practices and beliefs of your employees, unless doing so would cause an undue hardship. And when most people talk to the average person, what's an undue hardship mean? It sounds like it's something that's really significant, like some sort of significant difficulty or expense. And they would be right, because later on, Congress, when they passed the American with Disabilities Act, they used the same undue hardship language, and they actually defined it as significant difficulty or expense. But Congress did not define undue hardship in the Civil Rights Act. Well, there was a case that came along, TWA versus Hardison, and I don't want to spend too much time explaining that legal backdrop, but just enough so everybody kind of gets a picture of this. There was a statute that was on the books talking about, the Civil Rights Act that required religious accommodations. The EEOC issued some guidelines that included the undue hardship language that I was just talking about for the first time. This statute was then amended after that, but when TWA versus Hardison was before the Supreme Court, the issue that was in play was actually the regulations from the EEOC and not the amended statute. So when TWA versus Hardison came down, the issue, the holding of that case really dealt with the regulation and not the statute. And so the Groff team, in arguing, Aaron Street from Baker Botts argued the case, and he did a fantastic job. But And Preliger, Solicitor General Preliger, she did a fantastic job for her side as well, and we'll describe that a little bit. So Mr. Street, when he was making his argument, the argument that he was making essentially was, well, because it was interpreting the regulation and not the statute, the court today owes no statutory stare decisis deference to TWA versus Hardison, because the statute was not in play, and therefore any language dealing with undue hardship as to the regulation is actually only dicta as to the statute. And so therefore statutory stare decisis would not come into play. Brief definition of statutory stare decisis is, if most people know what stare decisis means, well, for statutes, when the court is interpreting a statute, there is a little bit of deference that the court engages in towards Congress, or towards previous court decisions by the Supreme Court interpreting a congressional act. And so if a Supreme Court decision comes down interpreting a statute, and later on the court wants to revisit that, the statutory stare decisis sort of asks some various questions to see if, in fact, this is what the court should overturn what they said themselves, or if the court should wait to see if Congress wants to reverse if they think it's an erroneous decision, an erroneous interpretation. And so that was an issue that was at play here. But Justice Thomas starts off rather quickly by asking, well, what we just described, wasn't the statute really not in play during TWA versus Hardison? And Mr. Street answered that the answer is yes. It was not in play. He ended up asking a variation of that question also of Ms. Preliger, and she concurred, but she had some additional gloss on that because the government really wants the court to apply statutory stare decisis. What was fascinating was Justice Kagan had an interesting observation. She said, well, statutory stare decisis would only apply if our past decision was wrong. So the fact that it was wrong, that if the court interpreted undue hardship wrongly before, then it would be obviously that's the only time you'd invoke statutory stare decisis, and therefore the fact that they got it wrong, or maybe got it wrong, should not be that big of a deal. It was sort of an interesting take on it. But the issue, what happened in TWA versus Hardison, and why it was such a big deal, was that the court in TWA versus Hardison declared that, or found that undue hardship meant not de minimis. Or de minimis. So in other words, if there was any de minimis cost at all on the business, de minimis, anything, then that was an undue hardship. Mr. Street, in his argument, pointed out that, well, that doesn't sound the same thing. I mean, undue hardship sounds, like how the ADA defines it as significant difficulty or expense, but de minimis doesn't seem to match just almost a dictionary definition of undue hardship. For the government's part, they actually didn't try to defend undue hardship equaling de minimis either in one sense, and then tried to defend it sort of in another. And it's really difficult to unpack it because the Solicitor General, she was very, schizophrenic is a harsher word that I would like to use, but I don't know what other word I should use to describe sort of the waffling around that she had. I mean, to be honest with you, the government's position seemed to grow emptier throughout the argument in terms of what was being offered as a substitute for Mr. Street's presentation was significant difficulty or expense, Ms. Preliger said, well, maybe undue hardship shouldn't mean de minimis as we understand it, but maybe we can redefine de minimis as substantial expense. And for her part, she pointed to the EEOC guidelines that came out after TWA versus Hardison, interpreting undue hardship. And she said that those guidelines seem to add a little bit more oomph, and that's my word for it. Ms. Preliger was much more articulate, but a little bit more oomph to the de minimis. So sort of a de minimis plus something that the EEOC guidelines seem to offer. And she pointed that, there had been some plaintiffs who had brought cases under Title VII who had survived summary judgment under the undue hardship standard as de minimis, and therefore that maybe this is not as difficult of a problem as Mr. Street was pointing out. And of course, Mr. Street was pointing out, well, goodness sakes, this is really a losing proposition for plaintiffs who are seeking to vindicate their civil rights guaranteed to them in the statute, because de minimis is really almost nothing and very easy for an employer to advance. And it really put like a giant wet blanket over the requirement of a religious accommodation that Title VII requires. And so as a result, there was a lot of back and forth between both sides, kind of talking about terminology, significant difficulty or expense on the petitioner side, substantial expense on the respondent side. Justice Kavanaugh kind of challenged both sides to say, well, what do these words mean? And what are the examples that you would talk about? And it was fascinating because the government kind of, Ms. Preliger kind of morphed her argument throughout to decide, well, there was some backpedaling, and she kind of landed on, well, we want to keep de minimis as a name, but maybe have a little bit more room for a requirement that the employers actually incur something a little bit more than just de minimis, but wanted to kind of continue to call it that and preserve all of the case law over the past 46 years that have been applying this watered down version of undue hardship under Title VII. And as a result, it was kind of difficult to grab a hold of whatever the real test that was being offered, other than some examples that Ms. Preliger provided, which were helpful, I thought, in terms of trying to figure out where the government stood. And one of the examples was they thought that payment of any premium wages would be an undue hardship, and and then providing any kind of time off exemption or exception to accommodation to somebody if it ends up causing a morale issue in terms of some people are upset about that would be an undue hardship as well. A couple of interesting points. Justice Alito asked about. He said, Ms. Preliger was sort of making taking the position that minority faiths have really been okay under the de minimis standard, and they've been fine. And Justice Alito held up a bunch of amicus briefs filed by various Muslim, Hindu, Jewish, Seventh-day Adventists, and other minority faiths, and said, well, they seem to disagree because they filed on the petitioner side. And there really wasn't a lot of conclusion from that, but I thought that was sort of a fascinating moment. Another interesting, fascinating moment was Justice Sotomayor. She seemed very concerned that corporations were not going to be profitable if they have to comply with all these burdensome government regulations. She seemed very concerned, and Justice Kagan shared some of that concern of businesses and corporations, corporate America, sort of suffering financial harm as a result of having to comply with civil rights statutes. So that was sort of a new and surprising phenomenon that happened during the argument. So anyway, the last thing that I'll say, one of the features of Mr. Street's opening, and there was no pushback really from the government, and really not a lot of use of this in the argument by the justices. So I don't know if they just didn't find it significant or what its significance will end up being. But the 30B6 deposition of the government revealed that they could not identify an undue hardship in this particular case with Gerald Groff. And fascinatingly, the postmaster for Gerald at the time of during all the disciplinary hearings or whatever could not said that prior to them sort of deciding that while they were accommodating Gerald, did not actually create an undue hardship. There really wasn't a lot of use of that. But what was also sort of surprising, we had a lot of discussion of this particular case during the oral argument. A lot of the discussion was, how do we find the standard? One last thing I'll say is several of the justices were, like Justice Gorsuch, for example, Justice Kavanaugh, Justice Kagan mentioned maybe we're all coming together, kumbaya, which was this effort of what is the common ground between both sides. The common ground seemed to be move away from de minimis. But when you drill down to it and with the examples, it didn't feel like the government was really committed to that in a meaningful way, more of a slogan way, but not necessarily in a meaningful way, because I think that they didn't want to get pinned down because they had argued and were continuing to argue during argument that they want to keep all the undue hardship de minimis precedent still intact. And we're simply suggesting a slight modification to that, but in sort of labeling, in a labeling aspect, but it was difficult to figure out in a substantive aspect how that would play out, because they seem to be confident that the current EEOC guidelines were good enough. I don't know that there's going to be a lot of discussion in the opinions. I mean, I'm not predicting that this case is going to turn on statutory stare decisis, because for it to turn on statutory stare decisis, I really think that you would have had to have the government defending the essential reasoning, the underlying reasoning of the original decision in TWA versus Hardison, and they completely abandoned that, both in the briefing and during the oral argument. And so there really wasn't an advocate for the old standard, as such. But Justice Kagan did, she made a good run at continuously raising the statutory stare decisis issue. And it seems that the fight there is between Thomas and Kagan, where Thomas is saying, well, I mean, technically it really wasn't. And I mean, I get your point that, well, some of the lower courts have treated it as if it is precedent, in a sense that it has some sort of like an effect of precedent, and therefore, can sort of, grow into that. But that's not really how statutory stare decisis works. You can't sort of, morph into it by accident. And Justice Thomas, I think, was trying to make that point, but Justice Kagan had a counterpoint to that. But for this case to turn on statutory stare decisis, for that to be meaningful, would essentially lead, I think, to Mr. Groff having a difficult time in the case. And I just don't think that the justices, at least there didn't seem to be enthusiasm with, for example, Justice Barrett or even Justice Gorsuch or the Chief Justice to support that kind of analysis. Certainly, Justice Kavanaugh didn't spend any time on that issue as well. So I suspect that while there was a lot of briefing on that issue, there was a lot of discussion on that issue, that it is going to not be something that is going to garner enough support on the side of treating Hardison according to statutory stare decisis, that it's going to matter a lot in the case. That's just my prediction, but I could be incredibly wrong.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.